address that in some fashion in the future. Yes?
Yes, sir.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
This is a preliminary matter. My apologies.
Thank you, Your Honor. May I?
Of course.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised two additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these two arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear.
Yeah.
I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic,
Sure.
or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that, and I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain, and the court, may have built in its thinking as to the other two of the state's arguments, but I don't know that that is reflected in the ruling, and I think it would help if it was.
Okay. I understand your position.
Okay. Thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay. Very good. Ms. Lewis, my apologies. No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well? Or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. Happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first. I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that, and then Kathy, you're doing
the other two.
And then Ms. Nestor's doing the other 2, so I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702. Based on her
Let's talk about that structurally.
Okay.
If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbernack will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gun Hill Dairy and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down, so it catches almost anything. And even if there's two witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So if the court wishes to proceed on to specific questions about Ms. Amon, then Ms. Sherbernack can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness. Within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. So whose witness is Ms. Amon?
Ms.
Ms. Sherbernack, can I ask you some questions?
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Amon's testimony, on 2 occasions, and in bold print, the state says Ms. Amon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Amon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Amon's testimony may be helpful to the trier of fact, to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence. But this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part.
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Amon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Amon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She
Right.
will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Amon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Amon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right?
well, yes, but also Ms. Amon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in
Sure.
Defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist, and Ms. Amon would not know who those people are.
I read her proffer. She seems to explicitly acknowledge that people stop at various points
Right.
along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always, no, that's not her testimony,
Okay.
and that's not factual. But for her to say, in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result, the attack has occurred, we can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sherman?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point, and
Is it cited in your brief?
no, because I didn't know about it.
Okay,
It's
can
something
you give it to me?
I just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument, because the way this works in courts, when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Amon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be mis-summarizing here. But there's a higher level to it. And when we look at Diaz is even more specific, and somehow a majority of the United States Supreme Court is like, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Amon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it
yeah.
is, and I did not reread that case. So I would actually
We can, we'll take a break at some point.
need
We
a
can
moment
compare.
to review that, to be frank.
Okay. Ms. Shervinack.
Oh, I'm sorry.
Oh, okay.
I do think that it would be helpful to hear Dr. Fox's
Sure.
testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes,
Right.
but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's it's junk science is what it is. It's not scientific. It's not used in the community. And I think that that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Amon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
Now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Amon.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and talks about and testifies that she did not do this,
That denies committing the crime.
then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem no matter how, and this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to.
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Shervan.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Amon's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell me her
Right.
view.
I understand,
of
but
the
she hasn't
science.
now analyzed it under the Utah
Okay.
law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So could you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you... Oh, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank you.
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's, and then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Okay, thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with threat assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Ammon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division. And in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly, you talked about that you worked with the BSU, and I know Ms. Ammon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
All right. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts, in a legal setting. I would say that my experience as a FBI special agent and, of course, as a research fellow in the FBI's behavioral science unit, where I evaluated and then tried to help improve the scientific validity of both profiling and threat indicators, is what really has motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessment, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay. Just wanted to make sure as we move forward. All right. So are you familiar with the pathway to violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just like by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say, this often it applies, this often it doesn't. There's no known error rate, there's no accuracy rate, there's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the Pathway to Violence is descriptive framework and not predictive.
Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would, engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, people that, our judges seen today, both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone who eats chicken goes to the moon.
All right. So does the Pathway to Violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name like so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence. Or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the Pathway to Violence model is doing, this is, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I'm aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You could write whatever you want as long as the publisher agrees to print it, you're good to go. In Ms. Amon's proffer, the pathway to violence model was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but that's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not like a legitimate, valid journal. And that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was only mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that, stamp of approval if it's not reliable and valid. That's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Amon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because, again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these side areas. So an example of this would be 2 evaluators could use the pathway to violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is, if you have 2 people stand on 2 scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on 2 scales at my gym and at my doctor's office and there's 2 different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, interrelated reliability is basically this idea that if 2 people use the same construct, will they get the same result? And if people are having the same scale, implementing it, and get different answers, it's not reliable. and it just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect. Integrated reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the integrated reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often, I'm almost done, but I'm sorry, what? Oh,
I didn't say anything. My apologies.
oh okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. That was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I've been finding, I didn't have the resources to really complete this in the way it should have been done. And it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, in 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, that was the 70s way, but we're doing this differently now. And the Pathways to Violence model was developed in that same approach. Educated guesses.
Okay. So Ms. Amon, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the Pathway of Violence model?
No, that's like a basic logical fallacy. That was probably on your LSAT exam, that you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this traits shared by attackers. They're young, male, Middle Eastern, and you could say, looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like, literally, it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, like, I don't even know how many digits out. 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw. By implying these group-level descriptives, you're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. Go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, think about the problems we have when we're talking about parole. We're talking about, risk assessment, when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act.
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, I mean, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict the violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than, any type of, long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh no, and that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here, and that's absolutely not the case. A domestic violence type of scenario, poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right, so just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, it absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do.
Ms. Fox, may I ask you just a couple of basic questions?
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Shervnak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon, is the state going to put Ms. Amon on, or only if I have questions, I guess would be
Ms. Shervnak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from her.
Okay. Ms. Amon, do you mind turning on your video and audio? May I swear you in, please? Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I'd prefer to focus my questions directly elsewhere, if that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. Affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localized sound. And the cats would inch forward. And they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI, to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m., but what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do, we would begin to look at the behaviors the person is demonstrating, and being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure, that is, behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past, a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation. It's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. In fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result, so violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence, and then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't, Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is, you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you, Ms. Ingham.
Just a moment. Good morning, Ms. Amon.
Good morning.
So, Ms. Chervenak asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about, well, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal, and a child in your school has risen to your attention as raising concerns for violence, for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child. And I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if, absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. Someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right, so you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. Yeah, I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer-reviewed studies that you can point to that adopt this?
All peer-reviewed studies, all of them.
What are they?
Well, I supplied a list to Ms. Chevernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model." And that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about?
Yes.
Okay. All right, so it's not a predictive model, it's a preventive model.
Right.
It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction, but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms, and you can say, well, you are on the pathway to violence, let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know, but how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list, whatever, that can look a million different ways, then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in, sort of an imminent countdown potentially to an act of violence. And that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late-stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world? Where you have stopped violence based on something that was brought to your attention?
Well,
how can you say that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
All right. it's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this?
No.
Okay. So people can come to different conclusions even if they're both well-trained people?
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway. You can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foskule, Randy Vorum, and Robert Fine arrive at the pathway to violence, that's data.
The journal we talked about, that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about, the study I referred you to is in 2024,
Okay.
just because it's the most recent one, specifically on the pathway and only the pathway, but the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate, true?
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay. Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write The Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent. He didn't write The Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry, I have no idea what you're talking about.
All right. Have you testified in a homicide trial about the pathway to violence previously?
I have not.
Have you testified as an expert previously?
I have not.
Can you give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay. I have nothing further.
Ms. Shervanack, anything further?
No.
Okay. Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a 10-minute break, and then we'll come back. Thank you. Come back at 11:10. Thank you. Court's in recess. Manuel.
Detective who was testifying based upon experience. And based on his experience, he said that in all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
The key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Amon is not an experienced witness. She didn't write this. She hasn't done, she can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to
Sure.
see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Amon offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on the briefing, is more nuanced. It seems to me that the state could use Ms. Amon's expert testimony in its rebuttal case, and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical, generalized argument made by the defense, then I think this testimony from Ms. Amon, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we've showed you elements of plan and preparation on behalf of Ms. Richins, you heard Ms. Amon, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all, this would be the first time that it's ever used that way. You heard Ms. Amon, this has never been used.
Well, that may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not, but I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time...
But they're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right,
It's
I'm agreeing
not
with you on that. We're past that.
All right, so my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand sometimes killings are targeted? We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
I guess I don't understand how that's helpful. Yes, isn't that general knowledge that sometimes killings are planned? I don't understand.
I don't know if it is or not, but it's that would be like if the defense is going to make the argument, these things are never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Amon under any circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's, if we were to make that argument, which I don't know, let's see if we were to make the argument, she's a mother, she wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
Yeah, but you changed my hypothetical. Ms. Amon doesn't comment in any way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Kouri Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms. Amon to come in under your hypothetical
No,
to
it
say,
does not.
no, that could happen.
Please stay focused.
Okay.
A general, absolute, categorical statement by defendant. Murder doesn't happen this way. There always emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but if you want me to exclude her entirely, I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that, in your view, the only way her testimony could be relevant is if the defense says this kind of murder would only happen in a enraged emotional state.
Yeah, or in response to a threat.
Or in response to a threat. That's the
Right.
only way this is coming in.
Right. That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance. I just think our general objection, though, is that it's just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that...
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
Well, one of many.
Sure.
It's not.
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case, there are competing expert testimonies regarding the standard of care and whether it was breached.
Well,
and they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony, and I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge. And
Or
they
their
might have
education,
different,
training, and experience. They're not citing studies most of the time.
but it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
In
applying.
Utah, he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
that's correct. But if none of the studies have to do with the domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So how is that even helpful?
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
Okay.
You're going to want the last word, because I think the
All right,
state's going
I'm
to
good,
quibble
yes.
with my ruling here. Ms. Chauvenet.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they, being the jury, could use the analytical framework of the pathway to violence, taking the facts that they've heard presented or theories that they've heard presented through witnesses, and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts a theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply, and that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702, and for those reasons it's admissible.
Okay, I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that to admit this is reliable under Rule 702 in any matter, I think is inappropriate.
Okay. All right. All right, the issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rules 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred, and based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field, and the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States v. Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety. Then Ms. Amon's testimony regarding the retrospective study of completed killings, showing a feature such as a preparation and plan over time, would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Amon's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Amon will ever be called to testify is also pretty low. But fact remains that there is not a basis to grant defendant's motion in full, because there is a cognizable basis upon which her blind expert testimony would be helpful to the trial of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Amon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Amon's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervinack, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis.
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
We do
What do you do, Throckmorton?
yes, Mr. Throckmorton would be
Okay.
next, so Ms. Nestor will be. Do you want to move, or are you okay there?
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the...
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone. Hold on. May it please the court, good morning. Your Honor, as far as Mr. Throckmorton's testimony, the objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions, or lack thereof, are basically, I looked at this, I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't
Right.
say she did. I can't say she didn't.
Right. You skipped a step, though.
Right. Well, I'm getting.
I mean, he does say with a much higher level of
Right.
probability
Right.
that Eric Richins didn't sign it.
Right.
He just
So-
can't say that it was with the same level of probability, or any, depending on the document,
Right.
that it was Kouri Richins that made the simulated forgeries.
Right, and the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them, and, you know, all of us are human and we all have eyeballs, and, or those of us blessed with the sight have eyeballs that work, and we are tempted to look at those things and compare them and contrast them, and it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. Even his finding that Eric, I believe the finding he had was a strong probability
For
that
one of them.
that Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, you know, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff, I'm going to send this back in the jury room, y'all can sit there and look at these initials, you can try to figure it out yourself if you think that he did it, but I'm, as an expert, saying I can't say Kouri Richins did.
May we pause there for a minute?
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert
Right.
who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well,
And
maybe.
it's not supported by the science. The second prong that we're
Pause
attacking.
with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is a permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way, from the state's perspective, is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that moment, that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically, for some reason, we need the power of attorney. They're not even saying he didn't sign it. Like, their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Kouri did. He said absolutely no conclusion as to whether Kouri did, but he also can't say for sure
hold
that
on.
Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used to obtain a HELOC.
Yes.
Okay. He's used a strong probability for that opinion, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
Certainly,
yeah.
and the jury can weigh his testimony.
Right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed a document or not, right? Because if he didn't, it leaves open the possibility that somebody else did. And then when we go to, well, does he have an opinion as to whether Kouri Richins was the one that initialed it?
Right.
I acknowledge that his level of certainty there is much lower, if not, there's no
Zero.
conclusive proof one way or the other.
Right.
But why wouldn't you want to let that in?
Right. Well, if
I mean, if
he
the state wants to
testifies,
call him to say it, it certainly doesn't hurt defendant.
yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, you know, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief. And to have a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report and where in the PCAST report the scientific community says, look, this is just a subjective, it's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously. But yes, he does. He states that in his report, which, you know, may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. You know, now we're, what, 3 years after the death, and he's just now being submitted new evidence, right, to evaluate, but that's what happened. And they gave him a report by the, like a notary page where the notary had signed. And he just on his own makes a conclusion that a date has been altered, a number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Rivers?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then
Okay.
if that report comes in, we're going to ask to redact that section of it.
Reports don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He usually has, he does in fact have demonstratives, and those will need to be disclosed to the defense, but the report's hearsay.
Right. And also whether or not, I mean, that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two-based argument that we've presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I've provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay, you'll get the last word.
Yep.
Mr. Burmester.
To clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know, we come up with 100 hypotheticals, but maybe something, she's a great businesswoman and somehow puts into question evidence that we might offer, which could include that power of attorney.
And Q1 and Q2 are definitely the power of attorney. Is Q4 also?
Q4 is when Mr. Throckmorton is asked, all right, we have some knowns from Ms. Richins.
Right.
Now, do the same thing you did.
Okay.
So with regard to those would only, that is how I would see us calling Mr. Throckmorton in rebuttal. Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed in your case in chief at all?
Oh, I'm not offering the case in chief.
Okay,
That's
got it.
precisely why.
I see.
It would have to be some facts that arise in the defense case
Got it.
that would implicate offering that exhibit, and therefore its authenticity would
Okay.
be at issue.
Understood.
Okay. So that leaves us with just the true stage application signature, which is indeed at issue, identity of the forger and identity of that insurance fraud count.
So there I understand the state's argument to be Mr. Throckmorton helps the trier of fact determine whether we've carried our burden on the forgery count related to that insurance application, because he says, he opines that it was probably not authored by Eric Richins and it appears to be a simulated forgery, full
Correct.
stop.
Yes.
Okay. And that, in the state's view, is circumstantial evidence that makes it more likely that it was forged by Ms. Richins,
Yes.
given other factors related to motive, access, et cetera.
Yes.
Okay.
Yeah, I get this. I was in the courtroom in Gersh v. Gersh, and so I know the court is familiar with Mr. Throckmorton, and we've proffered all those in our pleadings, all his qualifications. So I don't intend to talk about that. However, there is a notion, and Mr. Throckmorton is here, President Court, we can call him as a witness. He would talk about how handwriting comparison has been used in courts for 200 years. And since the 70s, there's been an intense professionalization of that theory. And that history goes to prong C for demonstrating its threshold. I would also just like to address two other things, and that is the pathway forward, 2009, where the scientific committee, who's addressing all, what is the status of every single forensic science? And there's a portion about handwriting, and the committee agrees that there may be some value in handwriting analysis. The scientists who composed this document, of course, hold DNA at that time as being the gold standard. obviously stated there were some things that need to be addressed, but certainly doesn't say it ought not be admitted. PCAST doesn't even directly address handwriting. It says all these other sciences like handwriting, these same things should be applied to them. But none of them say scientific community is rallying around some notion that it's junk science.
Certainly not in the state of Utah. I've looked. I cannot identify any time that Mr. Throckmorton has been excluded in the state of Utah. I can only find cases in which he's been admitted as an expert.
Unless the court has further questions.
I understand the state's position. Ms. Nestor.
Nothing else, Your Honor.
Okay. Before the court is the defendant's motion to exclude the expert testimony of Matt Throckmorton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins home, and that there are mere indications that the defendant wrote those initials. The court determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the charged forgery count regarding the True Stage insurance application and may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education training experience, and his substantial history and experience testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendant's objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Under C, the court finds that Mr. Throckmorton's analysis, because it is performed consistent with and measured against the SWIG-DOC standards, is generally accepted by the relevant handwriting analysis community. Moreover, even putting that aside, the court determines that his methods are reliable in as much as he is able to describe the way he compares the questioned documents to known samples of both Mr. Richins, the decedent, and also Ms. Richins, the defendant. He applies that reliable methodology to a sufficient set of known signatures, and he does so in a way that does not ignore any uncontroverted features of those signatures or other uncontroverted facts. That is, he applies his methodology to a sufficient set of facts or data in a reliable manner. Therefore, his testimony is admissible under Rule 702B. Finally, the court is not persuaded that his testimony, the probative value of which has been described, is substantially outweighed by the danger of unfair prejudice or other concerns under Rule 403. For these reasons, the defendant's motion to exclude Mr. Throckmorton in his entirety as an expert witness is respectfully denied. Mr. Burmester, do you need any clarification in the court's room?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Next.
Ms. Bonino
Okay.
is next, which Ms. Nestor is also handling that one.
Very good. You ready to turn to Dr. Venino, Ms. Nestor? Ms. Shervanek, is this one yours?
Yes, Your Honor.
May I ask you a couple of questions?
Yes.
Okay. Ms. Shervanek, is there any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
That he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that. We went through this for a couple of hours with Mr. Wright.
We did.
I spent some time on this yesterday. I don't know that there's any other admissible evidence that would show that Mr. Richins knew that anybody had attempted to hurt him.
May I have a moment?
Of course.
I think the court is aware of what the admissible evidence is, the testimony from Josh Kays and Cody Wright, that the
Cody
admissible
Wright's not going to testify, as I understand it, trial pursuant to, not at least regarding the events of February 14, 2022. I don't think he has any admissible testimony regarding that day.
He does. His admissible testimony are his observations, not the content of Eric Richins' conversation, but his observations about Eric Richins' demeanor,
You
how
didn't
his
see him.
voice
It was all
sounded.
it was all on the phone.
Right, but his hearing observations about his voice, how he seemingly sounded on the phone during those conversations, and not the content that aren't admissible because of hearsay rules, but there are observations that he could make through that phone call that is admissible.
Proffer that for me.
But this is exactly what Mr. Wright testified to previously.
I don't know that he can give that testimony regarding his observation of the manner in which he was talking without saying what he was saying.
I disagree.
You're proffering that Mr. Wright would say he sounded scared?
That he sounded somber, that he sounded concerned. I don't remember the exact words that he used when he testified, so I don't want to misstate those. But certainly he testified that during that phone call, Mr. Richins had a certain demeanor that struck him and that he remembered, and then he testified to what that demeanor was.
Okay. All right, let's assume that comes in. Anything else?
There are also text messages between the defendant and Eric Richins about the sandwich that was left, and
So let's be specific. There's
Sure.
a text message from June between defendant and her friend indicating that she left a sandwich. And then there's a text message from Eric to Kouri at 11:33 a.m. on February 14th saying he's not feeling well, I'm going to go lay down. If I don't feel well, I'll go to the hospital. Anything else?
Your Honor, may I?
Later in the day. Sorry, I don't have all of those messages at the forefront of my mind.
That's okay.
Your Honor, late in the day, late afternoon on February the 14th, there are text messages between the defendant and Eric Richins, which don't directly, he doesn't directly say something like, you just tried to poison me or something.
No.
But the state will argue that his messages and her non-responses for several hours, and then their ultimate exchange about, he says something like, I got dinner for you and left it on the seat of your car, or on the seat of my car. The state will argue that those indicate he was well aware of what happened on February the 14th at about 11 a.m.
Okay. All right. Okay. My concern is that in the absence of admissible evidence, in the absence of the jury hearing the content of Mr. Richins' statements to Kouri Wright, there isn't a basis for the jury to conclude that Mr. Richins was acting inconsistently by staying with Ms. Richins or not doing something more acute between February 14 and the day he ultimately died. And without a reasonable basis to find that he acted inconsistently, I'm not sure why Dr. Venino's testimony is helpful to the trier of fact. And I'm more concerned that under 403, it would invite the jury to speculate about whether there was, in fact, a prior history or prior experiences of domestic violence that aren't in the record.
I think there are other instances, other facts that would be presented at our case in chief that are maybe not on their face what people typically consider domestic violence, meaning physical abuse. And that's the crux of it. For example, if there is infidelity, why do you stay in a relationship? For example,
But
if
does Dr.
someone is...
Venino have anything to say about that?
What's that?
Does Dr. Venino have anything to say about that?
I think these go to the counterintuitive behaviors. These go to manipulation and control that exist outside of physical abuse in these types of relationships, which is exactly what needs to be explained. Because the jurors may have questions of, why wouldn't you leave if you knew you were being cheated on? Why wouldn't you leave if you thought this person was taking your money?
Well, hold on. The jurors, lay jurors, are perfectly capable of figuring the first one out in their everyday experience. The second one as well. The state, I think, has a more thought-provoking point of, if you knew somebody tried to kill you, why'd you stay with them? Now that, I understand, would require or may allow the admission of specialized knowledge regarding domestic violence relationships and cases. I got that. That's, I think, a valid argument. I'm just not sure there's any foundation for the jury to conclude that this relationship involved domestic violence before Mr. Richins ultimately died.
I think that the court is considering this as domestic violence in the context of a typical physical abuse case that we're not alleging.
I'm not suggesting otherwise. I'm more concerned with Dr. Venino talking about it that way.
And she would not.
Then what does she do that's helpful?
It's in her proffer. She can certainly testify to it, but it is the counterintuitive behaviors, it's power and control and manipulation outside of physical abuse that does not include physical abuse.
Okay. All right. Mr. Bloodworth, did you want to add anything?
Yes, Your Honor, thank you. As it relates to what I would most likely expect the testimony to involve Valentine's Day, why not? Why if you thought she just murdered you, do you still stay?
Right.
And it seems to me that where the court might be hung up is in the probative value of the evidence showing that he knew versus
Or lack thereof, or just
thereof.
lack of evidence showing that he knew.
The
Yeah.
probative evidence showing that he knew versus the prejudice that would come along with perhaps an improper inference.
An improper inference of something prior to February 14th.
Prior to
that's
February
not-
the 14th,
Right.
correct, Your Honor. So I don't know that at this point in time the court has the full amount of evidence that Eric knew, despite kind of some proffers just now. This may be a decision that the court wants to reserve on under the scope, kind of make the reservation of the court needs to hear the evidence that Eric knew. Upon hearing the evidence that Eric knew, the court can make a 403 decision. I think the court can make probably the 702 decision part of that today, but I think the court needs more information on the probative value of the evidence that Eric knew.
Okay. Pause there for a minute.
Yes, sir.
Ms. Nesser.
Your Honor, Ms. Dr. Venino, I think she's a doctor, she has certainly not been identified as a family relations expert, a good or bad marriage expert, a marriage counselor.
I know, but respond to what Mr. Bloodworth just said.
That's what I'm trying to get to. So if they're trying to argue that there's been infidelity or there's been arguments in their marriage, infidelity on both sides of their marriage, which is an answer to a question about why you wouldn't leave. But that goes way beyond what the narrow area that she's qualified in. She's qualified in domestic violence. If you look at her CV, 99% of it deals with sexual assault victims. A tiny percent of it deals with domestic violence in the home that is not connected to sexual assault. Almost all of it's connected to sexual assault. So her specialty, while they may want to put that case on that, that she was a bad wife or whatever they want to try to argue, this expert is being called to opine about violence in the home, not just being a bad wife or being, controlling or manipulative of your spouse, but of a spouse being in fear due to emotional or physical coercion to the point of being in fear. And there's zero evidence that I've seen in 10 terabytes, what are we up to, 12 terabytes? 12 terabytes of discovery. And if they've got some evidence out there that there was domestic violence in this relationship and I don't have it yet, I submit it's not coming in. So the prejudice would be outrageous to allow this witness to get on the stand and opine expertly that because there were problems in the marriage, that this was a situation that put Eric Richins in fear of domestic violence.
That's not what Mr. Bloodworth was arguing. He was arguing that I should wait to see how the evidence comes in the state's case in chief to determine whether they've laid a foundation for the jury to draw a reasonable inference that Eric Richins did in fact conclude subjectively that Kouri Richins tried to kill him on February 14th and then stayed with her. If they do, I think their argument that Dr. Venino's testimony is helpful to the trier of fact is stronger, and we can have a conversation about it today or tomorrow or in the future. If they don't lay the foundation, I don't think it can come in because it won't be helpful to the trier of fact, and even if it had some minimal helpfulness, it's the danger of inviting the jury to speculate about whether there was some other history prior to February 14 regarding domestic violence, whether they've misheard the evidence and are confused or misled. That's too high under 403. But Mr. Bloodworth's point on behalf of the state is rather than doing this by proffer, why don't you just hear it come in and then decide if we can call Dr. Venino after we've tried to lay the foundation for what we think we're going to be able to show?
Well, one of the problems is, if she's going to come in, there's things we as lawyers need to do to prepare for that. One thing, we may want to get a rebuttal witness. We honestly did not believe that her testimony would ever come in at this trial because there's zero evidence of domestic violence on Kouri's part, right? So there are things we need to do to prepare that preparing at the last minute puts us at a significant disadvantage. I think you're always entitled to revisit any ruling you ever make, right? You're the judge. You can revisit a ruling at any point in a trial if the evidence changes or something changes.
Certainly.
But as this evidence stands right now, they have not propounded evidence sufficient to get her testimony in at this point. If they do that later, then they can ask you to reconsider. But right now, I think the only proper ruling would be to rule that there's no standing right now to let her testify. If that changes, you can reconsider it. But right now, they've not propounded that evidence. I've never seen that evidence, and we're, a month out from trial. I seriously doubt we're ever going to see it. But that's what we would ask you to do at this point.
You acknowledge there's a little bit of internal inconsistency to what you just said. I agree with the last part, that I can say, well, she can't testify until you lay foundation.
Right.
But once I say they've laid foundation, you're going to be right on the horns of the same dilemma you just described in terms of needing to have a rebuttal expert prepared to go.
Right.
Okay.
Well, I mean, if it depends on your ruling, how we approach that, right? I mean,
Talk to me about, assume that there was foundation in the record today, that there was admissible evidence that Eric Richins had a subjective belief, well-founded or otherwise, that Ms. Richins attempted to poison him on February 14, 2022, and elected not to do anything about it. It would seem that that would satisfy the 702A standard for helpfulness for the jury in terms of explaining why people who suffer violence in a domestic relationship don't immediately get out of it.
that still doesn't mean that there's any evidence of that violence in the relationship. Even if
You got to
that,
accept my hypothetical,
right.
that he subjectively believed that she did and didn't get out. That would seem to open the door to Dr. Venino's testimony as helpful to the trier of fact. Do you disagree?
I would disagree with that.
Tell me
obviously. Why. Well, based on her area of expertise, as I read her proffer, her theory is, it's almost like, we use the word grooming in child sexual assault material cases, but that idea of being in such a violent and traumatic relationship that basically a person just gives up. It's kind of the
Well,
burning
that's
bed.
not what she says. I mean, quote, there are many reasons that a victim of intimate partner abuse doesn't simply leave an abusive relationship, including love/hope for change, economic constraints, lack of perceived acceptable alternatives, social isolation, and fear.
Right. There's no evidence of any of that.
No, but in my hypothetical, there would be evidence that he believed that was the case.
Okay. Accepting that hypothetical, that evidence that does not exist now somehow appears at trial for the first time ever.
Right.
And is allowed in, even though we object like crazy because they didn't give it to us before. The argument would be that her testimony, my understanding is she's a blind expert, right?
Right.
So she's not going to be able to take that evidence and analyze it anyway. So how does it change her position at all from right now?
Well, because right now, in the absence of the foundation that you assert is missing, that I have concerns is missing, that Mr. Bloodworth is saying, hold the phone, let us lay it at trial. I agree that her testimony would be unhelpful because it's not relevant to
Right.
the facts of the case.
Right.
If they lay the foundation, it suddenly becomes relevant to the facts of the case.
I don't know. I think it gets very, very painfully close to opining on the mental state. I mean, it's the same argument that you raised before when you were talking about the testimony of the profiler. right? Like, how close are you going to walk to that line that you're giving an expert opinion about what's inside someone's brain and then extrapolating that, one step over to defense counsel table, right? And, I mean, basically her testimony would be under circumstances where someone believes that their life is in danger, it's perfectly rational for them to stay, so it must show that they did believe it, but that they just didn't act on it. I mean, she's opining on what would be in Eric Richins'.
I mean, they'd offer her testimony for the inverse.
Right.
The fact that he didn't leave is not necessarily an indication that an attempt in his life didn't happen on February 14th.
I mean, I had a case very similar to this one time. I had a rape case where the victim of the alleged rape testified wholly inconsistently, like 6 different times about what happened to her,
right,
to the extent of like where it happened, how often it happened, in what position it happened. Everything was just absolutely in every statement she gave. And the federal government called a witness to testify, an expert, to testify that rape victims are more likely to be confused. So the fact that her statements are consistent with trauma and make it more likely that she was a rape victim, right? And we had this huge battle over that, about how far can you use an expert to explain away your inconsistent evidence, right? Evidence that's inconsistent with guilt. And it shouldn't be that you should be able to call an expert witness and say, hey, we're presenting something that's wholly illogical and irrational, but we're going to call this expert up here and say, well, this certainly would be a perfectly honest reason why Mr. Richins would believe that, it was a healthy thing to stay with someone who just tried to murder him, right? And so it eliminates their problem with their evidence, and it goes into his state of mind, which an expert shouldn't be called to testify about.
Well, we could talk about that under Diaz.
Right.
But, okay, I understand your position.
Yep.
Ms. Shervanek, Mr. Bloodworth, anything else today?
No, sir.
Okay. Let me take it. Oh, I'm sorry.
Sorry, Your Honor.
That's okay. Anything else on the record at the moment?
No, sir.
Let me take a 10-minute break. Okay, thank you. Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships, because there would be no foundation for the jury to conclude that the relationship between Kouri Richins and Eric Richins qualifies as a domestic violence relationship. In the absence of that foundation, Dr. Venino's testimony would not be helpful to the trier of fact under Rule 702A, and given its lack of probative value, it would be inadmissible under Rule 403, not only as not being relevant under 401 and 402, but also under Rule 403 as inviting the jury to speculate about whether there was some other evidence of a domestic violence relationship between these two that wasn't in evidence in the court. It might confuse the jury regarding the testimony that is admissible. It might mislead them regarding the reasonable inferences to be drawn from it. So sitting here today, there isn't a basis to allow Dr. Venino to testify. However, the state makes a reasonable point that the court hasn't seen all the evidence, isn't aware of all the evidence, hasn't seen how it would come in, and the state may yet be able to lay the missing foundation during its case in chief. And so while the court determines that sitting here today, there is not a basis to allow Dr. Venino to testify, the court acknowledges that that basis may arise through the state's case in chief if the state in its case in chief lays a sufficient foundation for the jury to draw a non-speculative inference that Eric Richins was aware that defendant tried to hurt him on February 14, 2022, the court will revisit defendant's argument that Dr. Venino's testimony should nonetheless be excluded under Rule 403, given the entire context of the evidentiary record at that point. In so ruling, the court also rules that Dr. Venino is qualified to offer this type of testimony under Rule 702A, and that her testimony, if it becomes helpful to the trier of fact, and if it survives a 403 balancing test, satisfies the minimum threshold for reliability under Rule 702B. Ms. Shervinack, Mr. Bloodworth, do you need any clarification of the court's ruling?
No, Your Honor, that's sufficient. Thank you.
Ms. Nestor?
No, Your Honor.
Okay. All right. Any other expert witness issues we need to handle today? Ms. Lewis?
Not today, Your Honor, no.
Okay. Mr. Burmester?
No, nothing for
Ms.
that.
Shervinack?
No, Your Honor.
All right.
No, Your Honor.
Okay. Sitting here at this moment, I'm not prepared to get too deep into the other motions in limine. May we take those up tomorrow? Any practical considerations that we need to think about, or are we just going to handle those one at a time tomorrow based on the papers?
Those are mostly going to be mine, Your Honor. Some of them are Ms. Lewis's. Alex has, I think, one or two. Mr. Ramos, sorry. The only question we had, and I'm just not sure, so these motions were filed privately because they deal with evidence that we're asking not be admissible
Right.
at trial. I didn't know if the court intended to have the hearing public or not public, because once it's aired, it defeats the purpose of why it was all filed privately.
I mean, there is some space between the way we talk about stuff and the documents. For example, there are certain documents or transcripts in which the state is seeking to admit a portion but not the whole thing, and it's sometimes because the part they're not seeking to admit would be unfairly prejudicial, not relevant, inflammatory.
Right.
Nonetheless, your point is well taken. Do you have a request?
Obviously, it would be our preference that it all be private, and then maybe your ruling could be public.
Sure.
Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast to all of our jury who now have received jury questionnaires and know they're on deck,
Right.
could be problematic. So we would ask that the hearing be sealed and then maybe just the ruling be made public.
Okay. What's the state's position?
No objection to that, Your Honor.
All right. Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by defendant related to a number of pieces of testimony, documents, audio recordings, video recordings, other pieces of evidence. The admissibility of those things is as yet undetermined. And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaires, and so there would be a reduced ability tomorrow, the day after, to investigate whether they're exposed to information regarding inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing to the public and to seal the audio recording of it so that it is available only to counsel but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record. Any clarification on that, Ms. Nestor?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. Folks, we're likely to get some weather tonight and tomorrow morning. Is 9:30 an appropriate time? Do you need a little more travel time?
10?
That's fine. 10 a.m., Mr. Bloodworth?
Yes, Your Honor, that works. I have one other
Please.
I
issue.
did too, but go ahead. Oh, I just had a question. I don't know if you're prepared to answer this, but we do have a number of motions tomorrow, and in terms of expediency, it would be helpful if you have specific things you'd like us to be prepared to address. Maybe if we knew some of that in advance, if there was particular case law you want to discuss.
No, I'm going to be going off. I mean, I do have lots of practical questions about, all right, who's offering this? How's it coming in? Right? Is this case in chief? Is this in repeat? I need to understand the order of events. But I will go off the papers. And I'm happy to follow your lead in terms of the order in which you want to do things. So talk to each other. If you want to do Mr. Ramos's first so he can go do something, that's fine. Will you just tell me how you want to?
He doesn't get to leave.
Okay. Anything else, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth?
Your Honor, clarification on the sealing.
Yeah.
The victim and defendant's family are permitted in the courtroom?
Certainly victim representative.
Just one.
Just one.
Okay.
Yeah. Would be similar to what we would do for jury selection, for example. So during individual voir dire, victim representative is allowed to be present. I don't even know if Ms. Richins wants a family member present.
I'm
So-
sorry.
No, out of abundance of caution, because they've received subpoenas, it's
Right.
probably better they not.
Okay. So if you would pick a representative for the Richins family,
I think there's two that are designated.
that's fine. I understand. Yeah.
Your Honor, one more thing. The state in some of its motions have styled them as motion to pre-admit.
Right.
The defense, in some objections, have said the state lacks, or the court lacks authority to pre-admit. I don't fully know what the answer is, but
Well, no, I certainly have the authority to say that, for example, defendant has admitted that she wrote a certain letter, so 901 is satisfied.
sure, that. But as far as the relief the state is requesting, if the state has styled it as a motion to pre-admit, the state would like to amend any of those stylings to a motion to determine admissibility.
Understood.
Thank you.
Okay. Some of my questions will be, is there a genuine issue regarding the the authenticity
Sure.
of this document? Who's your witness that's going to bring it in? Something like that.
Yes.
Okay.
No, nothing further.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I'm not suggesting that the defendant should do anything other than put the state to its burden of proof and require them to lay a foundation for stuff they want to admit. However, I do want you to be at least a little bit thoughtful on both sides of the V here about the juror's time and the court's time. And so if there are indisputably authentic documents that you can stipulate regarding authenticity and foundation, but you want to reserve and then discuss your arguments regarding admissibility,
Right.
let me know which one those
Your
are.
Honor, I actually have been spending a great deal of time on that. I've come up with lots and lots that we're willing to stipulate to authenticity. I told the prosecution I would get that to them, I think Monday, but something came up in my family and I wasn't able to do that, but I will try to get that to them by Friday.
Okay.
But there's quite a few documents that we're not gonna have a problem with authenticity, and we're not gonna ask them to bring in sponsoring witnesses or
Perfect.
like jail calls and
Yeah.
bank records and pictures and all that kind of stuff. And I mean, I'm doing it one by one by one, and we'll have a comprehensive list by Friday, hopefully.
Thank you.
Thank you.
Okay. Mr. Bloodworth, anything else today?
No, Your Honor.
Okay, Ms. Lewis?
No, Your Honor.
All right, we'll reconvene 10 a.m. tomorrow morning. 2 victim representatives are welcome to attend. The rest of the public will be excluded tomorrow. Please travel safely. Nice to see all of you. Please take care. Court's in recess.